Welcome back to the channel. Today we're talking about jury service and, which I thought would go hand in hand, double jeopardy. But if you're just joining our legal community, don't forget to like, comment, subscribe and hit that bell icon, otherwise you might miss out on new videos. And if you're interested in behind the scenes footage and further legal analysis, jump over to Black Belt Secrets at the link in the description. So jury service and being tried by a jury is one of those things that is famously enshrined in law from Magna Carta under clauses 39 and 40, which reads as follows: "No free man shall be seized, imprisoned, dispossessed, outlawed, exiled or ruined in any way, nor in any way proceeded against, except by the lawful judgment of his peers and the law of the land." So in other words, if you are being prosecuted and tried for an offence, so long as it's not a summary-only offence, you have the right to elect trial by jury. And this is actually something of an important discussion because many defendants come before the magistrate's court not realising that they might well have the right to elect trial by jury. If they were given appropriate legal advice, they should be told of the pros and cons of having a trial at the magistrate's court as against having a trial by jury in the Crown Court. For example, a trial at the magistrate's court can often be much quicker. There can often be much less publicity because publicity tends to come to the Crown Courts because they generally attract the more serious cases. However, statistically, you are more likely to be convicted in the magistrate's court, and you might well think that it will be more difficult to convince 12 members of a jury that you are guilty of an offence than a magistrate. However, if you do have your trial in the magistrate's court and you are convicted, you have an automatic right of appeal to the Crown Court, although it won't be heard by a jury. It will be a Crown Court judge and two magistrates. But nonetheless, if the charge is on indictment or it's an indictable offence and you elect Crown Court trial, then you will be tried with a jury. Now, jury service itself is not something that you get paid for as a juror, although there is a provision for expenses. You will get notified of jury service through the post, having been chosen randomly from the electoral register, and you must respond within 7 days. There are limited circumstances in which you can ask to delay your jury service, but ultimately, if you are called upon, it is your duty to do it. A very interesting story, in fact, and if I find the link to it, I'll put it in the description, but a judge was called upon to do jury service and wrote for an exemption. The response came back to say no, even judges need to sit on a jury. The judge wrote back and said, "No, I really can't sit on the jury on this case because I am the judge trying the case." And the response from the office again was, "Well, you'll need to take that up with the presiding judge of the court." The judge responded again to say, "I am the presiding judge of the court and I really can't sit on this jury." And ultimately, the judge was excused. Jury service can have quite an impact on your life that you might not otherwise have expected. Initially, the estimate, and I suppose the average, is that your jury service will last for 10 working days, although it is not uncommon for cases to last for 5, 6 weeks or even months, and you will be expected to turn up at court every day. Also, whether you're employed, you're self-employed, or even if you're not working, there is a daily amount of allowances that you can claim, which again, I'll put the link in the description. But some unexpected consequences of jury service might be that your employer refuses to give you the time off, but in fact, they must give you the time off for jury service. If your employer decides to sack you or threaten to sack you, that might be grounds for unfair dismissal, because after all, it's jury service and you don't have a choice. All of this on top, of course, of the fact that the case that you're asked to hear might well be very unpleasant and it may affect you for a long time to come. Jury bundles very often contain lots of photographs. You might be asked to watch video footage of something that may be very disturbing. If this is the case, there is support available and obviously you're encouraged to seek that out. Discussing the trial or anything about the trial is obviously completely forbidden, except of course with other jury members in the deliberation room. And you also quite obviously cannot publish anything about the trial online or in any other way. I cannot stress enough that this is contempt of court. You might be fined and even sent to prison. So trial by jury is often a hotly debated topic because it can be time-consuming, it can be expensive. Let me know in the comments what you think. Trial by jury, is it something that we should keep? Is it something that we should protect? Let me know your thoughts. Moving on to double jeopardy, it is a well-established doctrine that no one should be punished twice if they are acquitted or convicted in the first set of proceedings on the same set of facts. And this is often referred to as autrefois convict and autrefois acquit. But it's worth bearing in mind, however, that if there is a hung jury, which means the jury was unable to come to a conclusion, then the prosecution may seek a retrial. It also doesn't apply in the case of a simple caution, because a simple caution is neither a sentence nor a criminal conviction. The leading case on double jeopardy was Connelly and the Director of Public Prosecutions in 1964. It was a lengthy judgment which set out essentially 9 principles, broadly setting out the principle that I've described, where the facts of the case are either the same or substantially the same as those in the first proceedings. These principles have been refined over the years where different questions have come to the court, and the court has had to decide how to apply these principles in any given set of circumstances. And it is those words that has led to a lot of litigation on the subject. In other words, whether or not the facts were the same or substantially the same, to the degree that it would prevent another trial. And if the defendant is acquitted, but it's found that there was interference with a witness or a jury member, then the High Court can quash the acquittal, and then there can be a retrial in that case also. A great film with Sir Anthony Hopkins that plays on this principle is Fracture, and I will link that in the description as well. There are, of course, and you might well have guessed, some exceptions to this rule. Autrefour has never applied in Section 18 offences, that's grievous bodily harm with intent, where a person is convicted of such an offence, but then the victim dies of the injuries. The person can properly be tried with murder. It makes sense, of course, because murder is obviously much more serious than a Section 18 offence, and it shouldn't matter that the person died much later. And of course, to be tried with murder, it's not a requirement that the person dies immediately from the injuries that have been inflicted. And finally, although probably to be discussed in more detail in another video, there's a similar principle in civil litigation, where you cannot just relitigate the same issue with new or better particulars. So that's my overview of trial by jury and double jeopardy, which we'll call part 1. Drop your questions and comments below, which might form part of part 2. In the meantime, thanks for watching, don't forget to subscribe, and I'll see you next time.